Further hearing in the appeal of NHS Trust and others, and why?
Yes, Mr. Davis.
My ladies and my lords, you will have nestling on your desk 4 more tabs to be inserted at the back of what I'm going to call the new bundle, which is the rather large bundle handed up yesterday. We're not
encouraging you to fill it.
No, I'm not tempted to, my lady. Within that are 2 documents from Professor Wade. Perhaps I'll let you put it in the bundles before I start describing what they are.
Ah, yes, well.
So 18 and 19 are, first of all, a report at the time from Professor Wade, and 19 is a letter from Professor Wade very recently describing what happened in the case, which was at tabs 1 to 4 of the new bundle, which was the change in diagnosis of Professor Wade. And that was essentially due to video evidence and a smart test being done, changing his mind from vegetative state to minimally conscious state. So if the PDOC guidance had been followed right at the beginning, they would have gathered this information at the beginning and there wouldn't have been a change. But that was a case where the application for withdrawal was withdrawn. That's the only example I'm aware that the official solicitor has produced where a change in diagnosis has changed the course of proceedings where it was consensual to start with. Tab 20 is a news report in relation to the very case the official solicitor gave evidence about that was concluded within 2 months. And if you turn up that tab, you will see that notwithstanding the relative speed with which those proceedings were conducted with, if you'll recall, a case dropping out of the judge's list so it could be heard a month earlier, the husband in the case was still very dissatisfied with the way the case had been dealt with. You'll see that he said, 3rd paragraph, everyone involved agreed the doctor should stop providing life support treatment. He says he cannot understand why a decision has taken so long. Mr. Justice MacDonald said the man was angry and dismayed and felt very strongly the matter had taken too long to resolve. Over the page, 2nd paragraph, same quote repeated. Halfway down that page, similar comments. It's taken too long to resolve in circumstances which all parties agree on the way forward. As he sees, the judge says, all the process has done is prolong her suffering. Tab 21 is a note that we have produced on the Law Commission recommendations and the government response. Essentially, the recommendation, which you'll see described in the note, was not accepted by the government because it was thought more flexible to put the categories of case required to go to court in the code of practice. That could be amended more easily than if it had gone into primary legislation. So that's the essential reason. But we're not saying that there's an intention with the bringing into force of the MTA to abrogate the bland rule of practice. That's not our case. 2 points arising from questions asked yesterday. Lady Black asked about whether there was a duty on an IMCA to produce a report. There is under Regulation 6.6 of the Mental Capacity Act 2005, Independent Mental Capacity Advocates General Regulations 2006. So the short answer is yes, there is a duty on an IMCA.
Sorry, I haven't got that.
No, I haven't handed up that regulation.
But this is a duty to get an independent report?
This is a duty for an IMCA to produce a report, an independent mental capacity advocate, if instructed to produce a report.
Are we talking a medical report or a report from the IMCA?
From the IMCA. So they are this is where there's no one else available. There has to be a referral to an IMCA under Section 37, and the IMCA has to produce a report if instructed. And they look
On best interests.
on best interests. This was one of the hard cases put forward by Mr. Gordon, I think, that what is to be done if there is no family or close friends around.
Well, you're talking very helpfully about practice, and you referred us to the BMA submissions and evidence. What should we do about if anything, about the judge's declaration? Because on one view, reading it, it could be read as a declaration in the air that if you have consent between the relatives and a doctor, that by itself is sufficient. She didn't say,
No.
on the basis that I am satisfied that there is a satisfactory code of practice which is followed, or has been followed in this case. She didn't deal with that. She did recite what had happened.
She didn't. I'm coming to my Lord's point about whether she had it before her. She did have it before her.
Yeah.
It was quite a rapid hearing. I think it only took a day. There were a number of points in the air. Her Ladyship dealt with a number of them in the judgment. She didn't deal with the points about the regulations. But the short answer, my Lord, is that all of this is predicated upon the guidance having been followed.
Well, it oughtn't to be clear, because
Indeed.
Otherwise a declaration it could mislead.
Indeed, and we wouldn't want that. This is a highly conditional declaration. It is predicated upon the law and professional regulations having been followed.
But it doesn't say so. And
It doesn't say so. It probably should, my Lord, yes.
Yes.
But that isn't to say that the declaration should be overturned.
No.
The context must be made clear. And it wasn't disputed that the regulations had been followed in this case. Thorough best interest investigation was taken. An independent second opinion was obtained.
Yes.
But it was very much on the premise that all proper procedures had been followed. In relation to the argument below, my Lord, Lord Mance, asked about the change of direction of the argument. And I can explain it as follows. The short point is that the judge did have the professional guidance before her.
Which did she have?
She had we can look at it, paragraph 47 of the judgment. Which is MS 157.
This is the joint GMC, BMA, Royal College of
So
Physicians.
these are the separate, I'm going to take the court to the guidance that she had before her, but it's the GMC 2007 guidance, the BMA guidance, which I think is earlier, and the Royal College of Physicians, that's the PDOC guidance, has been followed in assessing condition and prognosis. But the reason that Her Ladyship didn't deal with this point about what has changed since Bland in terms of practice and procedure is that the way the official solicitor addressed the case before her was by seeking to extend Bland as a substantive legal right by virtue of Articles 2 and 6, the same argument in this court. And that's the OS Skeleton, 9th November 17, paragraphs 31 to 2, which is at page 46 of the appendix to 47, MS pages 187 to 8. And the official solicitor did not clearly rely on Bland as a mere rule of practice, although he did refer to the Shrivel lecture given by Mr. Justice Baker in footnote 29, which did suggest that. That is the premise of the Shrivel lecture, that this practice that existed in Bland and thereafter should be retained because there isn't a sufficient body of evidence. And that's the appendix, page 50, the footnote at MS 191. Because the judge found no Articles 2 or 6 rights on the facts, and the argument wasn't put in terms of, oh, well, we've got a practice that should be retained, she didn't deal with it in that case. But she did have, as I pointed out, the professional guidance from the BMA, the GMC, and the Royal College of Physicians before her, and that is as I said, paragraph 47, page 16, MS 157, and found that it had been complied with. It was not said at that time that Bland, as a separate argument, that Bland is a rule of practice which should remain because there was an insufficient body of evidence that had been built up since, or practice that had been built up since then. All I would say on that point is that although I'm unaware of any report that was envisaged in Bland on the current appropriateness of that practice, it was his decision to repeal Practice Direction 9E, which codified the Bland principle and extended it into MPS, although the rationale appears to have been, according to the ad hoc subcommittee, that a PD shouldn't contain a description of which cases should go to court as a matter of general principle, rather than a substantive agreement that it was inappropriate. Can I turn now to the comparative law, which I was finishing on yesterday? And can I first start with Lambert, which I'm going to call it, which is Authority 17, MS 995, and that's paragraph 72 to 79, and MS 1019, 1020. And it's clear, paragraph 72, that there is no consensus within 39 of the 47 Council of Europe states. So this is page 1019. So it's that page, that half page, and the half page over the page that covers the comparative law. In countries that permit it, paragraph 73, there is a possibility provided for either in legislation or in non-binding instruments, most often in a code of medical ethics. So the possibility to withdraw life-sustaining treatment is provided either in legislation or in non-binding instruments, but most often in a code of medical ethics. So should Mr. Gordon seek to distinguish Lambert from the position here on the basis that in Lambert there's a legal obligation to seek a second opinion in law, as opposed to simply strong professional guidance that you must do it, that wouldn't be a tenable reason to distinguish it, because it's clear, paragraph 73, that in most countries in the Council of Europe, it is not a matter of hard binding law. The detailed arrangements, critically paragraph 74, for the withdrawal of treatment vary from one country to another. And I say this is a key point. That's why Article 2, as we'll find when we look at Lambert more closely later on, finds that the detailed arrangements for permitting withdrawal of A&H is a matter within the margin of discretion of each country, because the arrangements vary from country to country. There was a consensus as to the paramount importance of the patient's wishes, paragraph 74, and the withdrawal, paragraph 76, is also subject to other conditions in addition to seeking the patient's consent, including that the treatment may no longer be in the patient's best interest, it must be futile, or withdrawal must be preceded by an observation phase of sufficient duration by review of the patient's condition. To paragraph 77 to 79, these are observations of the Human Rights Clinic third-party intervener, who presented an overview of national legislation practice concerning similar situations to this, plus also active euthanasia and assisted suicide. And the conclusion, and sorry, that was in Europe and America. And the conclusion was no consensus currently exists regarding those second and third categories, but there is consensus on the need for situations similar to this to be tightly regulated in those countries which permit it. In that connection, each country lays down criteria in its legislation for determining the point at which it may be performed in the light of the patient's condition, and in order to make sure that he or she is consented to the measure. But critically, final sentence, nevertheless, these criteria vary appreciably from one country to another, so it must be tightly controlled. But it's for each country to decide how that control should be arranged. There is also guidance, Council of Europe guidance on the decision-making process, which you'll find at paragraph 60, described at paragraph 60 to 68 of Lambert, and its authorities 66 as well. And that is a guide drawn up by the Committee on Bioethics of the Council of Europe with the intention of the facilitation of the implementation of the Oviedo Convention, and that's page 5, MS 2827.
Sorry, this is the real thing, is it?
Yeah, I'm referring to the real thing. I won't turn it up because of time, my lady, but it is a valuable resource given the intention behind it, and it's referred to expressly as being relevant in Lambert. So CANH is expressly identified as an issue, pages 12 to 13 of that document, MS 2834 to 5. It's not suggested that it must go to court, nor in the chapter 3, the decision-making process, which is pages 15 onwards, MS 2837. There is reference to a collective discussion at page 26 and taking a decision, page 27, MS 2849. But as I say, no suggestion that every case must go to court in that document. Can I ask you now to turn up tab 74, which is the study of Fickback and Martin of 13 jurisdictions. It is in Authorities Volume 8, MS 3107. 13 jurisdictions were analysed, and I would commend to the court reading this document in full. The conclusions were, and you'll see that at page 2, MS 3108, that only Italy requires declaratory proceedings in respect of all withdrawal of life-sustaining treatment of PVS patients of the 13 jurisdictions surveyed. In a number of countries, Australia except Queensland, New Zealand, Norway, the Netherlands, Belgium and Sweden, doctors should consult with the patient's family and next of kin, but they have unilateral decision-making power with the potential for recourse to the courts. In France, the patient's representative must be involved in any decision-making process, but as we'll see from Lambert, it's still a decision of the doctor at the end of it. Canada requires the consent of the patient's guardian or analogous representative, but there is no need to bring declaratory proceedings. And Germany and the United States, apart from Illinois, no judicial involvement is required where relatives and doctors agree as to a patient's wishes. And this analysis is also based on a couple of other studies referred to it, the Halliday, Formby and Cookson, Wilmot, White and Downey papers. So that's the comparative law. Can I move on now to the definition?
Could you just tell us what this document is? Because we've got the index page, but I don't think we've got the title page, certainly not electronically.
Oh, I'm sorry. The first page, the index page is the first page. It's if you look at the asterisk,
Yes.
It's a comparative study conducted by Dr. Veronica Fickback, lecturer at the University of Cambridge, fellow of the Centre of Public Law, and Stevie Martin, PhD candidate at the University of Cambridge, commissioned by the legal representatives for the respondent, the first and second respondents, my clients.
And the date?
And the date of it is, it's not dated. We can ascertain the date it was sent to us, lady.
Please.
It is January 2018. I just need to find the precise date.
Right. January 18 will do.
My lady, I'm grateful.
As far as I'm concerned, it will do.
Well, I can make further inquiries if that will help. Can I move on to the definition of prolonged disorder of consciousness? I don't think we've dealt with that first. A disorder of consciousness is one that has persisted for at least 4 weeks post-injury, but is still under investigation. That's the PDOC guidelines, which is Authority 62, and it's internal page 3 of those guidelines. Sorry, I'll give you the electronic page. It's 2422, the electronic page. And that's the page you see the definitions of various neurological states. So halfway down that page, 2422, you see coma, which is absent wakefulness and absent awareness, vegetative state, wakefulness with absent awareness, and minimally conscious state, which is wakefulness with minimal awareness, but minimal in the sense that Mr. Justice Peter Jackson referred to in first instance in Aintree, that it does cover a wide range from vegetative all the way to full awareness. Then 2429 at page 10, there are further concepts to do with permanency, and you will see 2/3 of the way down the page, permanent disorder of consciousness.
Sorry, which page is that?
This is 2429, internal page 10. We've got continuing, which is from 4 weeks or more, VS or MCS. We've got permanent. If the PDOC is deemed permanent, a prediction, and this is important, it's just a prediction, is being made that awareness will never recover. In other words, won't get out of, at the very best, high-end MCS. Although this prediction cannot be made with absolute certainty, when an individual has remained in steady state over a period of time, there comes a point at which recovery of awareness is highly improbable. So that's the threshold. And a permanent VS is more than 6 months following anoxic or other metabolic brain injury, or more than a year following traumatic brain injury. So head trauma has a better prognosis. You can recover later, in the sense of recovering awareness later after a head injury, as opposed to a metabolic insult, such as lack of oxygen, as in this case. And then at the top of the next page, the Guideline Development Group emphasised the need for careful individual evaluation, taking into account the nature and severity of the injury and the trajectory of change over time. These requirements are especially important where decisions regarding treatment and care are made on the basis of that diagnosis. So that's the key point. The doctors are thinking the diagnoses are particularly important where it affects the clinical decision. In case of genuine clinical uncertainty, a further period of targeting monitoring may be appropriate. There's also reference to permanent MCS, which is a more difficult concept to predict, and it includes, if you see the bullet points, patient's general condition and severity of injury, and there is, regardless of etiology or cause, first bullet point at the bottom of the page, if a patient's remained in continuing MCS for 5 years with no improving trajectory, may be regarded as highly improbable. Those are definitions. Moving on to some numbers, you had reference to the post note, which was Authority 77 yesterday, MS 3143. That says that there are between 4,000 and 16,000 patients in VS. So that is Authority 77, MS 3143. I think it should be Authority Bundle 8. Authority 77, MS 3143. So those are the numbers, between 4,000 and 16,000 patients in VS, and 3 times as many in a minimally conscious state. And those are the best figures that we are aware of. But it's not a precise figure, it's an estimate. You can see from the range that it's an estimate. Now, as to the number of applications made to court, again, all we have is an estimate, and that is found at Supplementary Documents, Volume 2, MS 331. The Kitzinger article estimates in the footnote that there have been about 100 applications to court in total.
In total?
In total. A small proportion of the number of patients who are out there. Can I next ask you to open the Supplemental Documents, Volume 1, Tab 4. And because it's Tab 4, we know it must be something written by Professor Wade, and it is. And this is an article on how often is the diagnosis of the PVS incorrect. And the key finding is, if you look at the summary at the beginning.
Could I have a page number, please?
My lady, yes, Supplementary MS, page number 49.
Yep.
And this is in reference to the figure of 40% misdiagnosis that we're aware of in non-specialist assessment, as opposed to neurorehabilitation analysis with serial recording. What Professor Wade says at the end of that summary is that significant diagnosis of awareness with an apparently vegetative patient having good awareness is rare, and that careful neurological assessment of the cause and routine measurement of awareness using, he said this, CRSR, but there are other structured tools that we look at, should further reduce mistakes. And he's looked at he's done a systematic review of studies investigating awareness in people with PDOC. And if you look at Supplementary MS page 53, clinical conclusions and recommendations, he repeats the point that it's rare for persons being legitimately diagnosed being in the vegetative state, having reasonably full awareness. Instances are rare. Most misdiagnoses have minor clinical significance, with the patient crossing an artificial boundary within a spectrum of responsiveness with minimal behavioural change. He says the evidence base is limited. This is in relation to misdiagnosis in general. Difficult to interpret and subject to bias. The 40% misdiagnosis rate misrepresents the data. The rate of clinically significant misdiagnosis is likely to be low. I now move to the intervener's evidence to provide some more numbers for the court.
Before you do, where do we find Professor Wade's qualifications?
I think we'll find it in his various reports.
Yes. Well, we can look for
The
them.
core bundle
Well, he's
contains his...
tells you who it is on page 49. But, what the acronyms are, I don't know. He's Oxford Brooks.
I think MS page 238 is his report of the 16th of October 2017, page 97 of the appendix. Consultant in neurological rehabilitation, professor in the same subject in Oxford. And you see what his areas of expertise are. The interveners bundle, supplementary page number 26, is the case for the ICS and the FICM. You will see at paragraph 3, it is said that life-sustaining treatment is routinely withdrawn or withheld from those lacking capacity in ITU. You'll see also that 18,000 patients a year die following such decisions in England and 3,000 in Scotland. 40%, this is paragraph 16 to 17, supplementary pages 31 to 2.
Sorry, I'm not sure I've got it in a bundle. Is it a...
Oh, I'm sorry, my lord.
Is it a...
So this is the interveners.
Oh, it's this one. Yes, I've got them. I've been using them loose, so if you can just tell me which you're talking about.
My lord, yes. So I was initially talking about paragraph 3
Of
the written case. This is the written case.
which?
Of the ICS,
Of the ICS, yes, thank you.
which should be at
Yes, I've got it.
supplementary page 27.
Yes.
Routine withdrawal or withholding of life-sustaining treatment from those lacking capacity in ITU. Then 18,000 patients per year die following such decisions in England and Wales, and 3,000 in Scotland. Then paragraph 16, you will see that 40% of critical care patients receive invasive mechanical ventilation. And that was the comparison I was making yesterday with how can one justify such stringent rules for CANH where there are no such rules for ventilation. 40% of intensive care patients receive invasive mechanical ventilation. 20% require drugs and treatments to stabilize their heart and blood pressure. 10% require hemodialysis, and more than 75% receive CANH. That's paragraph 16 to 17 on that page, supplementary pages 31 to 32. Medical treatment decisions are almost invariably taken on best interests, or in Scotland, benefit grounds, on the basis of consensual decision-making between the clinical team and the patient's family and carers. That's paragraph 24, supplementary pages 34 to 5. 70% of patients who die on ICU do so as a result of withdrawal or withholding of active treatment. That's paragraph 26, supplementary page 35. And it is the withdrawal of ventilation, vasoactive medication, and renal replacement therapy, and the double effect of medications to ensure patient comfort that leads to death rather than cessation of CANH. So that's paragraph 28. So there is a difference in terms, and that's supplementary page 37 to 8. So the actual cessation of life is much more likely to result from the withdrawal of these other life-sustaining treatments rather than CANH. But CANH is withdrawn at the same time without having to go through. See also paragraph 32, which makes the same point at supplementary page 39. In critical care, this is paragraph 31 of that same page, supplementary page 39, CANH is not considered different from any other form of life-sustaining treatment and will be withdrawn on the same basis. That's the first 4 lines of paragraph 31. Further down that paragraph, you'll see why CANH would be withdrawn because of gastric stasis or failure of the stomach to empty adequately. It's a frequent symptom in the dying critically ill patient, and continued feeding would not confer any benefit and may lead to distress such as nausea and regurgitation of stomach contents. Paragraph 37A, which is supplementary page 42, asserts that patients surviving critical illness frequently report, this is about 6 or 7 lines down, frequently report unpleasant, distressing hallucinations, and the interveners submit there's no reason to doubt that these hallucinations would not equally affect the patients under consideration here. So the fact that they're in prolonged disorder of consciousness and don't outwardly seem that they're suffering doesn't necessarily mean that is the case. There is some evidence that those surviving critical illness do have unpleasant symptoms such as hallucinations. Then there's reference at 37B to the cost of a critical care bed between £800 and £3,000 per day. That's no part of our case, I should say. This is not, our case is not at all based on the economics of any decision. If I can now turn to the BMA case, and if you can look at supplementary page 74, BMA written case at paragraphs 14 to 15. BMA notes paragraph 45 of the OS's grounds of appeal and paragraph 21 of the written case, in which he divides patients provided with CANH into two groups: PVS, MCS patients, in respect of whom he says they're often in a physically stable state and relatively well, and patients who are on the point of death. The BMA said that submits there's a third category of patients who, like PVS, MCS patients, could, with CANH, potentially live for a number of years. This includes patients who have suffered a severe stroke, are significantly cognitively impaired, but conscious, and I interpolate the word fully conscious, they're not in an MCS, or patients with degenerative neurological conditions or other conditions where there is a recognized downward trajectory. And the way I read that, the downward trajectory is linked to the degenerative neurological conditions. So the implication is that the first two groups, severe stroke, I think that's one group, patients who have suffered a severe stroke are significantly cognitively impaired but conscious. So that's two groups, sorry. You've either got severe stroke, significantly cognitively impaired but conscious, and those two groups don't necessarily have a recognized downward trajectory. And the third group is the degenerative conditions where there is a downward trajectory. And the significance of that is that paragraph 15, decisions to either withhold or withdraw CANH in these groups of patients are made on a regular basis in line with BMA and GMT guidance and the Mental Capacity Act Code of Practice, and they're made without recourse to the courts. And I know that my learned friend says it doesn't matter what other cases ought to fall within this category if you are with him, that there is a specially vulnerable category deserving of sufficient protection to require mandatory referral to court, even where there's no dispute. But what is the proper ambit of that category if my learned friend is right, that that this court does not have sufficient confidence in the robust, safeguards contained in the Mental Capacity Act, the Code of Practice, and the various guidance I'm going to show the court? If there is a subcategory of patients that require the protection of mandatory referral to court, well, what is the proper ambit of that category? Logically speaking, on no logic could it simply be restricted to those in a prolonged disorder of consciousness with PVS or MCS. It's excluding the coma patients, and it's excluding the aware patients in whom, and it's this third category that the BMA talking about, who do have CANH withdrawn or withheld in line with the guidance, but without recourse to the court. How can they be left out? Do they need less protection than those with a lower level of consciousness?
What about children?
Well, children, we've got no evidence as to what happens with children, but I am not aware of anything like the same frequency of referral to court in the case of children. I did anecdotally have experience of a child in a minimally conscious state, but even the medical profession was much more ready to wait and see in that type of case.
I was really thinking about the lack of capacity that children have. And
well, then there's no mandatory referral to court with children. No. Obviously, the parents need to be consulted and very closely, and there's a paramount need to reach agreement
And obviously, if the parents disagree with one another, that
then
would come to court.
There's an issue, of course. But that is what I say is the right division between cases that need to go to court and don't, where there is a potential for a doubt, where there is a doubt or a conflict that could potentially go to best interests. And that can be in terms of with an adult or even a child in whom wishes and feelings are known about, some dispute about what they would have wanted, or diagnosis, or prognosis, or any other circumstance that could be relevant. I wouldn't wish to restrict the category. Paragraph 21 of the statement of Mr. Chisholm, which is supplementary page 88. Well, paragraph 20 first expresses the BMA's view that there is no reason to differentiate between withdrawal of CANH in patients in PVS and those with other serious conditions. And that's what they say in their guidance. Paragraph 21 says that decisions to withdraw CANH from all patients save in PVS and more recently MCS, and decisions to withdraw other life-sustaining treatments such as ventilator support for all patients have been made frequently by clinicians in consultation with families without recourse to the courts. And if you look at paragraph 48, two examples are given. That is supplementary page 97 to 8. I'll leave the court to read those. I now go through the background facts very briefly. You have that in the core volume, Statements of Facts and Issues, paragraphs 7 and 10 to 19, which is MS 49 to 53. Patient in this case was deeply comatose from the outset. That's page 96, MS 237. Ceiling of care was agreed in the acute hospital at the instance of Mrs. Y on the 29th of June 17.
Forgive me, could you give me the electronic?
Reference to that, yes. It is, in relation to the ceiling of care, it is supplementary MS 23. That's
I thought you were referring to the Statement of Facts and Issues.
No, I was just giving that as a general reference point. We weren't able to agree all of these facts. Some of the facts are contained in further documents. But
So what do you want me to look at?
I'd like you to look at the supplementary report of Professor A, paragraph 2.5.6, which is supplementary MS 23.
So is that in supplemental documents?
It's in supplemental documents, volume 1, supplementary MS, page 23, paragraph 2.5.6. That's the reference to the ceiling of care in the acute hospital before reaching the rehabilitation hospital. The ceiling of care...
Sorry, the page reference in that? I'm sorry, I'm having trouble with the
No, I'm sorry.
electronics, and I do need to look at this.
So it is internal page 7 of this report, and it's supplementary MS page 23. It's paragraph 2.5.6.
Eureka.
I'm sorry, my lady, it took so long to find. But the point I'm making is that the family throughout have been extremely concerned in this case to not overtreat, because they know what he would have wanted. So a ceiling of care, do not attempt cardiopulmonary resuscitation order was already in place since the 29th of June 2017. He was then moved to the rehabilitation hospital on the 19th of July 2017. And if you look at appendix page 82, the family, which is MS 223, were concerned from the outset that Mr. Y would not wish to receive active medical treatment if there was no realistic chance that he would be able to return to work in his former independent lifestyle. can keep open MS 223, which is appendix page 82. So this document is Professor A's medical report, first one, 29/9/17, but I'm using it to illustrate the chronology in terms of best interest meetings on internal page 82, MS 223. And they are described in subparagraphs 1 to 3 on that page. And just in brief, there were best interest meetings first on the 21st of July 17, again the 10th of August 17, and then, importantly, on the 8th of September 17. And at that point, and the notes of the meeting, if you turn back, you will find at page 75, and if I can pick it up at page 75, MS page 216. Cognitive is indicated at the bottom. And this is just after 3 months in, and we'll see the PDOC guidance. If you haven't, there's no trajectory of improvement after 3 months, then your prospects of regaining consciousness and certainly no disability are extremely limited. So this is not an inappropriate time to start looking at what wants to be done. So the final 4 lines, where a patient has been in PDOC for several months following hypoxic brain injury, you remember that's the worst of the 2 categories, hypoxic as opposed to traumatic brain injury. They are likely to have profound cognitive and physical disability, remaining dependent on others to care for them for the rest of their lives. This has been explained to the family, and they all understand this. Over the page, its assessments demonstrate a very low level of responsiveness, no evidence of meaningful interaction, consistent with VS. At this stage, we cannot say for certain whether he will remain in a VS or move into MCS. He's very unlikely to emerge into full consciousness. Family have told the team he's a very active man. For him, the only outcome that would represent acceptable quality of life would be to recover his independence and ability to work. They accept this is highly unlikely, and under these circumstances, they're in agreement that he would not wish to continue to receive life-sustaining treatment in any form. So that is when the family say that it is not, that that's what he would want, and yet that's very unlikely, according to the clinical assessment. Now, he was on, and the family asked the hospital to consider withdrawing CANH at that point. They also asked the family, so this is the 3rd paragraph, family have asked the trust to consider withdrawing CANH and or insulin, because he developed developed diabetes rising out of the index event. And if the agreement had simply been to withdraw insulin, subject to, and if he was a true insulin-dependent diabetic, that may well have resulted in his death. And there's no legal requirement to have referred that to court. That isn't actually what would have happened here, because this is appendix page 86, MS 227. He didn't have diabetes before the index event, and he's not truly diabetic. It's a temporary glucose intolerance, and Professors A and B agreed that stopping the insulin would not necessarily change his condition. He didn't need insulin anymore. It wasn't a withdrawal of life-sustaining treatment decision. But let's hypothesize if he had been a true IDEM patient, insulin-dependent diabetic, there would have been no legal requirement, unless Mr. Gordon says that that should also have been referred to court. But I don't think he's been saying that. We then have the reports of the professors, Professor A, at appendix page 79, MS 220, saying over 10 weeks there were 23 WIM assessments and 18 CRSR assessments, vegetative state with no trajectory towards improvement. And the bottom line was very severe brain damage, no clear trajectory of improvement, and even if he were to regain consciousness, will continue to have profound cognitive and physical disability, remaining dependent on others. Similar advice to the best interest meeting, and that's at page 81, MS 222. Professor B reports on the 16th of October, that's the appendix, page 95, MS 236. And he agrees, he says at paragraph 518 it's VS, and there's no prospect of any further improvement. Paragraph 6.1 MS 247, and because he doesn't believe the legal threshold of 6 months for non-traumatic brain injury is evidenced, he considers it's in reality permanent vegetative state, though he accepts that it's technically, if you follow the guidelines, you wouldn't call it that. So at this point, we've seen that there have been 2 opinions from world-respected clinicians in this field, both of whom were members of the PDOC guideline group, agreeing on the overall prognosis, although there is a subtle difference between them as to where they see permanency in terms of response. There's a supplementary report, Professor A, 30 October, page 86, where it's agreed that approaching 5 months post-injury, it's highly improbable he'll reemerge into consciousness, page 87. And the point about the diagnosis of PVS not normally being made after 6 months is also made, page 87, MS 228. The PDOC guidelines, I think I need to pass over that actually. It says, you've got them, we're going to look at them in a minute, but it says that the large majority of those who will recover consciousness after non-traumatic brain injury will have done so after 3 months. That's why the 3-month period is a significant period in non-traumatic brain injury. So we know that on the 22nd of December 2017, Mr. Y died. 3 months after the best interest meeting at which it was agreed that he was very unlikely, even with continued CANH, to receive an outcome that he would find acceptable from treatment. And on the 8th of February 18, we have the OS's report. He was first instructed, Mr. C, to provide a desktop report only on the 20th of December 17. That's why he wasn't able to examine, because even though the OS was informed on the 31st of October about these proceedings, Mr. C was instructed first, formally, to do a desktop report on the 20th of December. That report was received by the Trust on the 8th of February. I think it was dated end of January. And Mr. C agreed that the prognosis of a patient, this is paragraph 5.1, appendix page 130, MS 271, that the prognosis of a patient with hypoxic brain injury which results in a PDOC is unfavourable and rather poor, taking account the functionality of the person concerned and the level of disability. Yet, he recommends...
Sorry, which paragraph is this?
This is paragraph 5.1, MS 271.
Thank you.
Should be right at the back of the 4 bundle.
Yep.
And the heading is outcome or prognosis. He does consider that further investigation is required. That's paragraph 2.11, 260. And that seems to be based on 211 and 212, but primarily, if you look at what he's emboldened, one behaviour on the 29th of August 2017, when HY was observed to exhibit behaviour 15 on the whim, which indicates he was able to perform physical movement on verbal request. So there is a question as to whether he is able to respond, and he may not be in a vegetative state. According to Mr. C's rationale at 211 and 212, and on that basis he recommends that further investigation is appropriate. The next point in the chronology is the 9th of February 18 letter from solicitors for the wife, which is in, I think, some of the documents that were handed up today, which I read yesterday, illustrating just what a stressful and difficult time Mrs. Y was having, and how fragile she was, and tellingly how she has mixed feelings about the matter. And we can see why those feelings might be mixed.
Sorry, where was that?
Oh, I'm sorry. We've got copies of that letter. I haven't handed it up. That was the letter I read out yesterday, my lord. I wonder if I might just hand up that letter. It's been sent to the court when the third respondent withdrew from this appeal. But one can easily imagine what her sentiments would be, given her experience of what both she and the family and indeed her husband have had to go through to establish what treatment is in his best interests. Then two final documents, which I won't take my ladies and my lords to. Professor...
Sorry to interrupt, but could we see the letter, a copy of the letter?
You could. You have seen it before, but I'll... Oh, you've never seen that letter? Well, I think your solicitor's seen it. Two other reports, Professor A and Professor B both wished to respond when they were sent. Mr. C's report wished to respond to it. I'll tell you where it is. It is in the Supplementary Volume 1, Tab 2, Supplementary MS 17. Professor A answers each of Mr. C's points. Okay. And paragraph 2.4, Supplementary MS 21, says in relation to paragraph 211 of Mr. C that that one behaviour was investigated further and found not to be reproducible and was therefore not significant. It wasn't left.
Sorry, Mr. Secretary, what is the reference to this response?
This is the Supplementary Volume 1.
1, yes.
Tab 2.
Very well, good.
And it is paragraph 2.4.
Thank you.
Where Professor A, in particular on the first page, 2.4.1 through to 2.4.4, and if you read 2.43, in Y's case, the specific behaviours were, of course, further investigated through targeted clinical evaluation. They were not found to be sufficiently reproducible to meet the criteria for MCS. So that whilst one might see an ostensible disagreement 2 months after death in Mr. C's report, who has not examined the patient, that point that he founded his disagreement on was already dealt with by the clinical team. They had in fact investigated. But he didn't talk to the clinical team before writing his report. So what looks like a significant disagreement, a potential for a mistake, is not one. Professor B, his response to the report and a further letter by Mr. C criticising his conclusions is at tab 3, and he agrees with Professor A's analysis and deals with Mr. C's paragraph 2.11 point at paragraph 6.1 and 6.3, MS 44 to 5. So the question I ask rhetorically is, given that the guidance had been followed, all the evidence regarding wishes and feelings had been taken into account, and there are just two cases I would like the court to read in relation to wishes and feelings, and they are the family's witness statements in this case, which you will find at Appendix 93 to 94, MS 2345. I wonder if the court could read those two documents.
Sorry, what was the MS?
MS 234 and MS 335. Wife says, I'm writing about my husband, so I've consulted everyone in the family. We are all sure that he would not want to be kept alive like this. Been married to him for nearly 25 years. We met when working as bankers in the same company. I know him better than anyone, and I'm certain he would not value the kind of life he would have if treatment continued. Our children have the same view. This matter has been discussed with his brother and sister and his parents, and there is nobody who believes that he would want to continue treatment. Everyone agrees he would hate to be helpless and dependent on other people for his daily needs. He would not want to live in a care home. I understand that he's in a vegetative state that's nearly lasted for 4 months. As time goes on, less likely his condition will improve. I know it's too soon to say his vegetative state is permanent, but you've explained if he does develop any awareness, it would be likely be nothing higher than a minimally conscious state. He would not wish to be kept alive in a vegetative state or in a minimally conscious state or with profound disabilities. Then there's reference to the active person he was and that he won't be able to work again or do the active things he enjoyed. He would hate that. We haven't had a specific discussion about this, but we've all thought about this carefully, and on behalf of his family, I ask you please to stop treatment and let my husband pass away peacefully. And the children write over the page, you're writing to let you know our father would not hope to be kept alive in this situation. Our father was always full of life. Halfway down the third paragraph, he never expected this situation to happen. We never discussed what he would want if it was in the current situation, but he was a very active man who always sought to make the most of his life. We are certain he doesn't want to be trapped in the world like this. We are sure he would hate being dependent on others and that he's unconscious and cannot move or see anything. He would definitely not wish to live in a care home. We've thought about this very carefully and ask you please to stop the treatment and let our father pass away peacefully.
And how old are they? Roughly.
They're adult children.
That's what I thought, yes.
I will get the ages. Early 20s, I'm told.
That's the impression I had.
So the blanket rule covers just this case as well, and we've seen on the facts whether how Mr. Y and his family have what they've had to go through in order to give effect to his wishes and feelings. Can I turn now to the general law of patients' access to medical treatment? Can I open up Burke, which is Authority 11, which is in Authorities Bundle 2. Tab 11. And this is, I won't go through it now. I'll point it out to the court because I'm not going to go through it. Paragraph 67, I think, onwards, through to 80 requires close reading. That is Lord Phillips' analysis of the very question raised in this court. Is there a legal requirement to obtain court authorisation before withdrawing ANH? And his conclusion is in the negative. But the human rights arguments are not put in the same way that they're put in this appeal. But what I want to focus on is paragraph 50, 49 and 50. Paragraph 49...
could I have a...
I'm sorry, my lady. 814 and 815. So at the end of paragraph 49, Mr. Justice Munby, whose decision was successfully appealed in this case, says, paragraph 99, if the patient is competent, or although incompetent, he made an advance directive which is both valid and relevant to the treatment in question, there is no difficulty in principle. The patient decides what is in his best interest and what treatment he should or should not have.
Well, the difficult words are should or. There's no
Indeed.
problem with should not.
Indeed. Well, my lady is ahead of me. The GMC were concerned about these passages. My lady's judgment in Aintree specifically refers to this passage and approves the conclusion of Lord Phillips. The GMC is concerned that these passages suggest a doctor is obliged, if the patient so requires, to provide treatment to a patient or procure another doctor to provide such treatment, even though the doctor believes the treatment is not clinically indicated. And these are 5 very valuable principles that Lord Phillips lays down. And subsection 5, if the patient refuses all of the treatment options offered to him, this is a competent patient, and instead informs the doctor he wants a form of treatment which the doctor has not offered him, the doctor will no doubt discuss that form of treatment with him. But if the doctor concludes this treatment is not clinically indicated, he is not required, i.e. he is under no legal obligation to provide it to the patient, although he should offer to arrange a second opinion. So the doctor decides what range of treatments are potentially of clinical benefit. The patient decides which of them to accept. If the patient wants something else not offered, there is no obligation to provide it if the treatment is not clinically indicated. I now move to Aintree, which is the best guide of how the Mental Capacity Act works. If you wouldn't mind opening Authorities Volume 1, which is the Mental Capacity Act, and also Authorities Volume 2, which is Aintree. And if we can first look at MS 286, which is Section 1 of the Mental Capacity Act, setting out the principles. 2 to 3 set out MS 287 to 8, the test for incapacity, and Section 4, which is critical for this appeal, a mandatory method of ascertaining best interests, MS 288, in determining for the purposes of this Act what is in a person's best interests. The person making the determination must not merely make it merely on the basis of age or appearance or condition, etc. Subsection 2, the person making the determination must consider all the relevant circumstances and must take the following steps. There's a mandatory procedure to go through. And there's a mandatory list of considerations, which is, first of all, you must consider all the relevant circumstances, and then in particular take the following, my word, procedural steps. Consider recovery of capacity, ability to participate in any improvement of that, life-sustaining treatment, whether he's motivated by desire to bring about the death, that's the intention to cause death. Then critically, 6 and 7 must consider, so far as is reasonably ascertainable, past and present wishes and feelings, beliefs and values, and other factors, and also must take into account, if practicable and appropriate to consult them, the views of anyone named by the person, anyone engaged in caring for the person or interested in his welfare, and some other people listed there as to what would be in that person's best interests, and in particular as to the matters mentioned in subsection 6, in other words, wishes and feelings and beliefs and values. And then section 5 is also critical to this case, because we say if there's a substantive legal obligation to to come to court, as opposed to a rule of practice, it implicitly limits the section 5 defence. If there is illegality, substantive illegality, involved in making CANH withdrawal decisions without coming to court, then it cuts across section 5. And section 5, you'll see, provides a defence, subsection 2, in relation to liability if P had had capacity and had consented to D doing the act, if subsection 1, subsection B, A and B, before doing the act, reasonable steps are taken to establish whether P lacks capacity in relation to the matter in question. Secondly, when doing the act, D reasonably believes in the lack of capacity and that it will be in P's best interest for the act to be done. So there is a standard of reasonableness in relation to defence from liability, but it doesn't exclude liability if the act has been done negligently, subsection 3.
Could you just go back to 4, please?
Lady,
Who,
yes.
in that context, is on our facts, is the person making the determination?
It's the clinician in charge. I mean, the statute doesn't specify.
No.
If the decision is a decision whether to withhold medical treatment, it would be the clinician in charge of the patient. In law, there is a clinician who's in charge of the patient. But they take the decision as part of a multidisciplinary approach. They don't simply...
Yes, I'm just thinking in statutory terms. And
Section 4 applies to any person taking
Does.
decisions under the Act, so it applies to a court, it applies to a donee of a lasting power of attorney, it applies to a deputy.
Indeed.
But for the present purposes, it applies to whoever is making the decision under Section 5.
Indeed.
That's a person who is doing an act in connection with the care or treatment.
But in law, the withdrawal would be the treating clinician's decision. They would be...
Well, I think that's a very interesting question. It makes no difference whether,
No.
in fact, it is the treating clinician who makes the decision or whether it's, in fact, the person who actually
Indeed.
turns things off.
Presses the button.
Both should be protected by Section.
Indeed.
I was wondering whether it was the family as well.
Well, they don't take the decision. They have an input, a vitally important input into providing the important substrate. That's turning rather chemical, but the decision, a lot of the content of the decision, as we'll see from Aintree, is what the person would have wanted in that position. And that's where I'd like to turn. But my essential observation is...
But just in relation to the family, it would not be unlawful for the clinical team to continue to treat, even though the family said don't.
Indeed.
So
Yes.
the critical, or the family's input is important under Section 4,
And Section 4, yes.
but the actual determination is that of the clinicians
Indeed.
under Section 5.
I would agree with that.
Is that correct?
That's correct.
Yeah. Because in Re-F it was decided that the family don't have the right to decide.
Indeed.
That's
Well, even from the law in Burke, the patient doesn't decide what treatment they have. The patient's family doesn't decide. It's the clinician applying his or her clinical experience, knowing the facts, decides what treatments to offer. And the patient can't insist on any particular treatment if the doctor considers it's not in the patient's clinical interests. Essentially, the Mental Capacity Act sets up a regime that is permissive. It does not, the statute, and this is conceded by the appellant, does not compel any particular type of decision to be brought to court. The way it works is, as we'll see from Aintree, if I can ask the court to open Aintree at Authorities 2, tab 8, and this is an absolutely key authority for the purposes of this appeal, not simply because it's the leading authority on the Mental Capacity Act in relation to medical treatment or treatment in general, and what best interest means. But we know that the Act provides for decisions to be made on behalf of people who are unable to make decisions for themselves, asking whether it's in their best interests, and that's MS 640, paragraph 1 and 18 in the second and final sentences. Then at paragraph 18, that passage in Burke, about halfway down that page, is specifically approved. Baroness Hale's judgment, paragraphs 50 and 55 at 600E to F, MS 640. And then, importantly, paragraph 19, treatment given must be lawful. This is MS 640 to 641. Generally, it's the patient's consent that makes invasive medical treatment lawful. You can't treat a patient with capacity if he refuses. You can't treat a patient who lacks capacity if there's a valid and applicable advance decision to refuse it, or if P has granted an LPA, which expressly applies to life-sustaining treatment, and that's paragraph 19, MS 640 to 1. And where a P is unable to consent to treatment, it's lawful to give her treatment which is necessary in her best interest, paragraph 20. Paragraph 22, the focus is on whether it's in P's best interest to give the treatment. If not, the court will not be able to give its consent on his behalf. It will be lawful to withhold or withdraw it, and it will not be lawful to give it, provided they've acted reasonably and without negligence. The clinical team will not be in breach of any duty towards P if they withhold or withdraw it. And that's my point about the extreme undesirability, once it's clear where a patient's best interests lie, for there to be a significant period of delay before their best interest, but before the clinicians can act on what is in their best interest. And they don't need to wait in any other case other than withdrawal of CANH from patients in a PDOC. They can withdraw ventilation after having gone through the procedure and analysed best interests and looked at diagnosis and prognosis. But it's just in this subcategory of cases where there is both a question under domestic law as to whether it's lawful to carry on giving this treatment once it's clear that it's not in someone's best interest. And secondly, a question, as I put it to Lord Mance, arises under Article 8. I'm not saying a breach, because there does need to be a system, which no doubt would be a question for the margin of appreciation, during which time a court needs to ascertain whether it's a lawful withdrawal. So I don't put it nearly as high as that, but it is a relevant consideration. Then, from practitioners' perspectives and the practical application of the law, the next point is particularly important. Paragraph 24 and 39. Best interest, the test contains a strong element of substituted judgment. The person's preferences are an important component in best interest. That's at paragraph 24, 643, and paragraph 39, MS 647. One must try and put oneself, this is paragraph 44, MS 648, in the place of the individual patient resuming a quality of life which P would regard as worthwhile. And it's not for others to say what is worthwhile. And obviously in Aintree it was a gentleman who wanted to have all possible treatment, but the same principle must apply where a patient doesn't want all treatment. What matters is the quality of life that they would regard as worthwhile, paragraph 44. The purpose of the best interest test is to consider matters from P's point of view, paragraph 45, MS 648. Then there is reference to the code at paragraph 29. 28 extracts the code 5.31 to 5.33. And there's reference in 5.33, and this part of the code refers to life-sustaining treatment in general and not withdrawal of A&H in particular. But at 5.33, the point is made that final three sentences, MS 644, if the doctor's assessment is disputed, there's no other way of resolving the dispute. Ultimately, the Court of Protection may be asked to decide what's in the person's best interests. And in the following paragraph, paragraph 29, the code is accepted as an accurate statement of the law. And that's about 6 lines down. Both the judge and the Court of Appeal accepted them as an accurate statement of the law, and so do I, although it's not to be construed as a statute. Then the most critical paragraph is paragraph 47 for the purposes of this appeal, other than the general point that the Act is permissive, and that is the approach that Aintree approves rather than a mandatory referral. And this is really important because I know that another line from Baroness Hale's judgment in another case, the N and ACTG case, is heavily relied upon by Mr. Gordon as providing evidence that some cases are so serious they have to be referred to court in any circumstances. But this, Aintree, was a case about life-sustaining medical treatment, and the comment at the third comment at paragraph 47 is directly on point, whereas the ACCG case wasn't about life-sustaining treatment at all, and that paragraph, I think paragraph 38, needs to be read as a whole. So what my lady said in Aintree is, third, if the clinical team are unable to reach agreement with the family or others about whether particular treatments will be in the best interest of the patient, they may of course, bring the question to court in advance of the treatments being needed. So even in the general field of life-sustaining treatments generally, and Mr. Gordon has repeated that the point here is that someone has a life, has an interest in that life being protected. So the principle, actually, if you're worried about rates of misdiagnosis and inappropriate withdrawal of life-sustaining treatment, should really be at the level of life-sustaining treatment in general. The general rule with life-sustaining treatment is that if there is a disagreement, the clinicians, or indeed the family, may bring the disagreement to court. That's as high as it's put.
So where is the word may? I haven't got this passage. I thought we were at 39.
47.
47.
I'm sorry.
I'm sorry. No.
Letter F.
609E,
Yep, I've got it.
MS 649.
I have it.
And it starts third if the clinical team.
Yeah.
Will you rely on may? I mean, I can't understand really how they could do other than bring the question to the court, Mr. Sanchtiva.
My simple point, my lord, is not whether in the case of significant dispute or dispute going to best interest, where it should come to court. Everyone agrees that it would be highly advisable to do so, because the Section 5 defence may not protect the clinicians. But that's the mechanism. Well-advised clinicians, with awareness both of their professional obligations and their general position in law, would not wish to run the risk of not being protected by a Section 5 defence if later on questions are asked about why they withdrew CA&H, because the potential is of being accused of murder. That was a submission made by the official solicitor in Bland, that to do so, even when in the best interest of the patient, would be murder. And there aren't too many clinicians who would wish to run that risk.
Of course, it would also be possible for the family
Of course.
to bring proceedings.
Of course.
To prevent.
Entirely possible, and it's well known, obviously, there are a number of cases in which that has happened. And if proceedings are brought, the family often actively participate. But I say it's critical. I think the significance of the word may is that there is no legal obligation to bring it to court, but there are very strong legal incentives, if I can put it that way. Because if one wishes to be able to practice without civil or criminal liability or professional misconduct findings, then one would bring that sort of case to court. So the distinction is between may and must. And the must doesn't apply to, certainly, Baroness Hale did not say, not that she was being asked to say, did not say that one must bring all life-sustaining cases to court regardless of whether there's a dispute or not. And that's really where we are with this, with the official solicitor's position. Can I give you one more reference, which is Authority 71, which is simply to the effect that the standard of care is a reasonable standard of care. That's Lord Dyson in the ZH case, and that is, I think, Authority 8. Authority 7.
8.
No, correcting myself. And it's MS 3053, and it's in particular at paragraphs 39, 40, I think, which is MS 3068. Striking feature of the statute of defence is the extent to which it's pervaded by the concepts of reasonableness, practicability, and appropriateness. Strict liability.
Sorry, which page you...
This is page 3068, paragraph 40 of Authority 71. This isn't in dispute, but it's a concept pervaded by reasonableness. Strict liability has no place here. So that's the general standard in medical treatment, reasonable. Right, can I now turn to the Article 2? Hope to talk about 3 more things before I'm finished. The Article 2 case, the common law arguments, which will turn really on what has changed legally and in terms of guidance since Bland, and then just tidy up a few submissions at the end. So you will find our arguments on Article 2 and 6 in our written case at paragraph 66 to 97, which is MS 120 to 129, and also 115 to 130, which is MS 132 to 7. But I'm not going to read that out, you'll be relieved to hear. I would like, though, to turn to the Lambert Authority, which is Authority 17, which Mr. Gordon says gives us no useful guidance in this case as to what Article 2 would say. We submit otherwise. Now, this was a challenge to doctors' decisions, a doctor's decision to withdraw CANH from a patient who turned out to be in PVS. So it's Authority 17, MS 995. Article 2 has both negative and positive aspects. At paragraph 117, MS 1027, you will see that the court held that the limb enjoining the state to refrain from the intentional taking of life was not engaged by discontinuing a form of treatment, which at 119 they call therapeutic abstention, which is quite a helpful phrase, to be contrasted with euthanasia and assisted suicide. And in cases of therapeutic abstention, where withdrawing or withholding treatment that had become unreasonable, the applicants in that case argued that the negative limb was engaged. And at 124, importantly, the court said that the distinction between the intentional taking of life and therapeutic abstention was a distinction that the court thought important. And in the context of the French legislation, which prohibits the intentional taking of life and permits life-sustaining treatment to be withdrawn or withheld only in certain specific circumstances, the present case does not involve negative obligations. As to the positive obligations, it's covered between paragraph 126 to 182. And I can first turn to the submissions of the applicant, 126. The second paragraph, the applicant submitted the process leading to the doctor's decision, which under French law is the doctor's decision, was incompatible with Article 2. The procedure was not truly collective, as the doctor alone took the ultimate decision. They maintained that alternative systems were possible, which would allow other doctors or the members of the family, in the absence of a person of trust, to participate in the decision-making process. They argued that legislation should take into account the possibility of disagreement between family members and make provision at the very least for mediation. So there was a submission that the procedure, without providing for mediation, breached Article 2. It was not nearly as ambitious, and I say that neutrally, as a submission that it had to go to court to satisfy Article 2, with simply a mandatory requirement for mediation in the event of dispute, which the applicants were arguing for. And the government's response is at 127 to 128. 128 emphasising the procedural safeguards and the fact that the decision was subject to review by a judge, but not referred as a matter of obligation. And at 136 onwards, existing case law is assessed. And at 140, context is described. The state is required to take appropriate steps to safeguard the lives of those within its jurisdiction in the public health sphere. And in the public health sphere, these positive obligations require states to make regulations compelling hospitals, this is MS 13032, whether private or public, to adopt appropriate measures for the protection of patients' lives. You see the general way in which the positive obligation is expressed by the court. The court then stresses the context at 141, and at 142, I've made reference to this paragraph before, referring to the Haas case. It was appropriate in the context of examining a possible violation of Article 8 to refer to Article 2. The court in this case said the opposite is true. The converse also applies. In a case such as the present one, reference should be made in examining a possible violation of Article 2 to Article 8 of the Convention and the right to private life. A reference is made to Pretty in relation to avoiding what a particular person would regard to be an undignified and distressing end to her life and the potential for an interference with Article 8. Then there's reference to the Pretty judgment itself. And at 143, so it is relevant, the fact that a procedure would necessarily, in some cases, require some individuals to suffer an undignified and distressing end to their life by, for instance, having to wait for court proceedings to take place before they could have an end to their life that they would consider dignified. I put it no higher than that Article 8 is relevant. That's what Lambert says. And at 143, the court will take these considerations into account in examining whether the state complied with its positive obligations. And referring to Glass and Burke in the European Court, and in the European Court, the court upheld Lord Phillips' decision that the GMC guidance didn't breach the human rights that the claimant said it did. But the analysis of the court, taking into account the previous jurisprudence in Glass and Burke, is it took into account the following factors: the existence in domestic law and practice of a regulatory framework compatible with requirements of Article 2, whether account, and you've seen in the Council of Europe document, or you've seen reference to it earlier in Lambert, has been taken of the applicant's previously expressed wishes and those of persons close to him, as well as the opinions of other medical personnel. Then critically, the third point, the possibility to approach the court in the event of doubts as to the best decision to take in the patient's interests. And if there was a mandatory requirement under Article 2 to approach the court, even in the event of no doubt, one might have thought the court would have seen fit to say so here. Because the possibility to approach the court is nowhere near the same as a requirement to approach the courts. That's why I say this case is not about European Convention case law, because Article 2 doesn't go anywhere near as far as Mr. Gordon would say that it does, and Article 6 is not engaged if there's no contestation, which there isn't. And doubt is not simply the official solicitor hasn't agreed yet. That is not a coherent definition of doubt. But this third point in 143 is extremely persuasive as to the ambit of Article 2. And that's why I say the real point in this case is whether Bland should continue or whether there is a sufficient body of experience now such that Bland whilst understandable at the time, is no longer, and I won't have time to go into this, but their lordships all thought that it would be a temporary rule that was going to be reviewed, and indeed Lord Gough had some misgivings as to whether it was required at all, and hoped that it would not be needed relatively soon. I wonder how many of them would have expected it would still be in place and extended 25 years later. That's why I'm going to go to the guidance shortly, but this is what the court has said about Article 2. The court will take these factors into consideration in examining the present case. It will also take account of the criteria laid down in the Council of Europe's guide. I've referred the court to that. I think it was Authority 66. Then,
before you leave that page, paragraph 140,
yes.
These positive obligations require states to make regulations compelling hospitals. Is it your case that that is the Mental Capacity Act, the provisions requiring consultation and so on?
Well, that certainly complies with that requirement. I'm not saying you would need it in statute.
But it, in fact, is there in the present situation?
Yes, it's in fact there, and there's a very strong code of practice explaining everything you'd possibly want to know about the Mental Capacity Act, subject to these two, I would say, inconsistent aspects of 618 and 818, which the official solicitor relies upon, which relies on seriousness as the reason for picking out CANH cases in PDOC, but that applies to all life-sustaining treatment, that justification.
They've always been there. They were there at the time of Aintree, were they, those two paragraphs?
I believe so, my lord, yes.
They're
They've
not,
been there from the beginning.
Yes,
they're not referred to in Aintree, no.
they're not. And I would like to say they're inconsistent with 531 to 533, but if I'm pushed, and there isn't time for you to push me, but so I'm going to push myself, I would say that there is seems to be a rule for life-sustaining treatment and a sub-rule for CANH in PDOC cases, and the question for this court is whether that is justified or not. So 144 to 148 is also critical because the finding is that at 147 in particular, there is no consensus between the Council of Europe member states in favour of the concept itself, withdrawal of artificial life-sustaining treatment, although the majority of states appear to allow it. And also, importantly, second sentence of 147, the detailed arrangements governing the withdrawal of treatment vary from one country to another. There is then reference to the fact that there's consensus to the paramount importance of the patient's wishes, but I wish to emphasise the earlier point, which is that there is variation as to the arrangements for withdrawal, even within those countries who permit withdrawal. And critically, 148, the arrangements for withdrawal are a matter for the state itself, being within the margin of appreciation. States must be afforded a margin of appreciation, not just as to whether to permit the withdrawal of ANH and the detailed arrangements governing such withdrawal, but also as regards the means of striking a balance, and that's what we're talking about here, between the protection of patients' right to life, and the official solicitor has stressed the importance of protection, but on the other side of the coin, protection of their right to respect for their private life and personal autonomy. The more procedural obstacles there are, then the greater the level of interference in personal autonomy. But that is the answer as well, apart from the substance of Article 2 not extending so far as to require certain procedural all matters to come to court, 143, third point, but also the concept of the arrangements is within the margin of appreciation, so it's not going to be a breach of Article 2 to have an arrangement that's different from your neighbouring country. And there is also reference at 161 through to 168 to the decision-making process, and this is very important as well. The applicants complained of the decision-making process, which should have been genuinely collective. In other words, the doctors alone shouldn't have been able to decide the answer, but at the very least have provided for mediation. 162, it's a similar point that Article 2 cannot be interpreted as imposing any requirements as to the procedure to be followed with a view to securing a possible agreement, and then it makes reference to Burke. And then the French law collective procedure with several consultation phases, but it's the patient alone, it's the doctor who alone takes the decision, fourth line of 163, with the patient's wishes taken into account and reasons. And at 165, it's clear from the comparative materials that in those countries which authorise the withdrawal of treatment and where that patient has not drawn up in advance directives, there exists a great variety of arrangements governing the taking of the final decision to withdraw treatment. It may be taken by the doctor. This is the most common situation. So reflecting the FIC-FAC analysis, it may also be taken jointly by the doctor and the family, by the family or legal representative, and then finally as a possibility, or by the courts. And then at 168, the court noted the absence of consensus and considers that the organisation of the decision-making process, including, I say critically, the designation of the person who takes the final decision to withdraw treatment and the detailed arrangements for taking that decision, fall within the state's margin of appreciation. Mr. Gordon says this case is about who takes the decision. is it the court in this subcategory of cases, or is it the doctor? Well, Article 2 says that the identity or the designation of the person who takes the final decision is within the margin of appreciation. So it cannot possibly be something that breaches Article 2, an argument that this designation of person isn't enough. Then, in terms of Article 6, can I ask the Court to read 185 and 186? The Court rejected that complaint as manifestly ill-founded insofar as it wasn't dealt with under Article 2. I ask the Court to look at the other authorities in the written case. Afiri is the most recent one. I won't take the Court to it. It is Supplementary Authority, Volume 1, Authority 1, Supplementary MS, page 4. It followed Lambert, paragraphs 27 to 28. And that was the case about the possibility of a judicial remedy in cases of doubt being sufficient. So that is Supplementary MS, page number 4, first tab of the supplemental documents. There was no need for parents to have the power of co-decision in a case involving, intriguingly, withdrawal of mechanical ventilation. So that is precisely my analogy, that the European Court does not treat mechanical ventilation cases differently from CANH cases, but Mr. Gordon is asking you to do just that. He says founded on Article 2, but I don't have time to go to that case now. But can I now turn to the common law argument, because I only have, I think, roughly 15 minutes left. And can I first deal with the official solicitor's concept of clinically stable? And that will require me to turn to Authority 32, which is in Authorities Bundle 4, the M case of Mr. Justice Baker, which is MS 1461, and a similar argument was run in that case. If you look at paragraph 98, MS page 1492, and apologising in advance, Authority 31 is the same case, but the weeklies didn't include quite a lot of the evidence, which is relevant in a minute. But the point here is that at paragraph 98 onwards, Mr. Justice Baker identifies the legal issue. There was one significant legal issue between the parties, namely whether a matter of law, the court should adopt a balance sheet approach in respect of an application concerning a patient who is in an MCS. And the OS argued that the balance sheet approach should not be adopted in cases where the patient is otherwise clinically stable. They argued that the balance sheet cannot apply in such circumstances, as it can never be in P's best interest to withhold or withdraw life-sustaining treatment. And at the bottom of paragraph 101, MS 1494, the PCT submitted the OS's approach was wrong in law and unworkable in practice. And at 102, the judge expressed that he was wholly unpersuaded by the official solicitor's argument and fully accept the trust's argument. So clinically stable is wrong in law and unworkable in practice. And at the bottom of 102, the judge says it would lead to lengthy satellite litigation as to the meaning of clinical stability. As to the law, I would refer the court to our written case, paragraph 51, and all the cases that have dealt with this common law argument. In particular, the argument was properly had in the Peter Jackson case of Re-M. The earlier cases in W&M, you must go to court, paragraph 257, was just the judge reciting PD 9E. There was no argument on it. In Briggs and Briggs, there was no argument on this particular point. But in Re-M, the argument was squarely put. The OS wasn't the litigation friend in that case, but he was asked by Mr. Justice Peter Jackson, as he then was, to put in submissions on this very point. And that is the argument Mr. Justice Peter Jackson dealt with. So I would ask the court to read that authority in particular.
And where do we find it?
Oh, my lady, it's in the... So Authorities Volume 2, I think, is the one that you'll find yourselves coming back to more than any other. And it is in tab 14.
Do you want us to look at it or simply?
No,
you don't?
well,
No.
in your own time, if I might, I come back to
Well, some of us have read it already.
guillotined quite soon. But, well, since we've got it open, let me just very briefly deal with it. Paragraph 28, MS 947, the need for proceedings. And this is a case which the official solicitor said was obiter because it commenced in the Court of Protection. The judge decided, as he was bound to, that he would deal with the best interests issue first, so as to not put P at any disadvantage in relation to deciding this very interesting legal argument as well. And the judge described it as a topical issue in paragraph 28, and then describes whether it's a legal obligation has received recent consideration, and sets out the various points. At 30, subsection 3, MS 948, OS was invited to provide observations and provide a substantial skeleton, and submissions were set out at 32 and 34, and the judge set out his conclusions at 37. I would ask the court to read that carefully. And his conclusion was that there was no legal obligation. But what has, and the points of principle, so I've dealt with, under this heading, the common law argument, concept of clinically stable. Secondly, the law, our written case, paragraph 51, and the points of principle, which were the 10 points I gave the court yesterday as to why there shouldn't be a common law principle that these cases must go to court. What has changed since Bland? Well, in the law has been very closely clarified since Bland. It's evolved much more closely to follow P's wishes and feelings. And I don't have time to go to it, but the W&M case, Authority 32, is the first case where the applicant sought the withdrawal of CANH in MCS. And the main finding in that case was that there was jurisdiction and to do so, because it was doubted by some that it was even possible to go to court to seek such a declaration before that case, notwithstanding the terms of the MCA. It was. And Mr. Justice Baker said, yes, there is. Read the Mental Capacity Act. But on the facts, he refused to place, and this is a really critical point that one can see how Aintree really changed the law, at least in the interpretation of the law.
I'm not sure that we thought any of
No, I'm
we
sure
were changing the law.
my lady knew what the law should be anyway. I think the rest of us weren't quite so clear, but Aintree has certainly clarified it. But one can see it.
Please don't blame me alone. It was a unanimous judgment, including some very important people.
My lady, no, but my serious point is that one can really see what a difference Aintree has made if one compares W&M Authority 32, and particularly paragraphs 228 to 230, especially 230, which is MS 1498-9, and also the statement of just how strongly she felt. That's Authority 31, which is the same case, paras 107, which is MS 1421, and 112, 1422, and 119, 1423. Suffice it to say that M would not have wanted even to go into a care home, and at paragraph 230, Mr. Justice Baker places almost no weight on those wishes and feelings because they weren't specific enough. It wasn't contained in an advance directive, and they weren't specific enough for the judge to place weight on. Then we have Aintree, strong element of substituted judgment, and then we have 3 illustrative cases after that showing cases where life-sustaining treatment has been withdrawn after evidence of general, well, some specific and some general evidence as to what the person would have wanted following Aintree. These authorities are M&N, Authority 30, Briggs, which would repay close reading, that's Authority 10, and that's a case where there was withdrawal of CANH from a patient who was potentially improving but wouldn't have found the realistic best case scenario acceptable. And that's paragraphs 30 to 31, MS 765, 39, 100 to 1, which is 109, and 109, which is MS 783 and 786. And Mr. Justice Charles expressly refused to follow W&M as to the weight to be placed on wishes and feelings, because in very few of these cases has someone sat down with their relative and said, well, if I'm in a minimally conscious state negative, MCS minus, please don't let me carry on. And we've seen the European materials require weight to be placed on formal and informal expressions of opinion. That's why AINT is so important in really giving content to wishes and feelings and from whose perspective it is from. Then the final authority is Salford, which is authority 39. The case turned, paragraph 23, MS 1889, on what P would have wished for herself, rather than the medical differences that there were in that case. And P, Mr. Justice Hayden found, would have found her present circumstances not only intolerable, but humiliating. Paragraph 39. In that case, P had pulled out the NG tube 50 times, paragraph 17, MS 1887, and the judge was concerned that she'd been significantly discomforted by the NG tube and for a considerable period of time, which may well have been avoidable due to the delay in bringing the case to court. And that COP cases must always be driven by the needs of the patient and not by the exigencies of the litigation, paragraph 42, MS 1896. Right, the medical changes. Mr. Justice Baker says in Authority 31 in W&M, over the past 20 years, medical understanding about PVS and MCS has progressed very considerably with development of various structured tools. That's paragraph 55, MS 1402. The guidance. Now, we've set out the guidance, and it's important, I say, to look very carefully at these four sets of guidance, and I'll tell you what they are. First of all, the BMA guidance 2007, and that's Authority 65, MS 2685. And I would invite your attention to paragraphs 9, MS 2708, paragraph 12, MS 2711, especially 12.2, which says the GMC's guidance, which is binding on all doctors, requires that a second clinical opinion is sought before ANH is withheld or withdrawn from a patient who is not imminently dying. So the GMC require it. Paragraph 29.4, MS 2754, and paragraph 30, MS 2757. The GMC guidance, which is the second type of guidance, 2010, Authority 64, MS 2598, which was commended in Aintree, paragraph 47, as sensible, says that there's a presumption in favour of prolonging life, paragraph 10, MS 2611. The decision-making model with incapacities at paragraph 16, MS 2615. Critically, paragraph 27, there's a mandatory second opinion required, as in the Lambert case, where there was a mandatory second opinion in the process. If there's a decision that CANH be withdrawn or not started, where the incapacitated adult is not expected to die in hours or days, that's paragraph 27, MS 2622 to 3, and that's a really important paragraph of it. And there's also reference to it at 119 to 121, which is MS 2656 to 7. And you must approach the court if you're considering withdrawing nutritional hydration from a PVS or condition closely resembling it, paragraph 126, MS 2658. Two more sources of guidance. The PDOC guidance, Authority 62, MS 2402, and I commend that this is read in full. The defining criteria and terminology are set out at section 1, MS 2420. You've had a look at that. states at page 4 that many clinical teams have little experience of PDOC, and you must involve clinicians with specific experience and expertise in the assessment of PDOC. That's page 4, MS 2423. On diagnosis, page 14, MS 2433, misdiagnosis is a significant problem, and this gives a requirement for evaluation by a multidisciplinary team of clinicians who are expert in assessing cognition, etc., in the context of PDOC. And there's a very useful summary of their recommendations, which is a précis of the earlier pages, at page 33 to 5, which is MS 2452 to 4. Advice on best interests is given at page 54, MS 2473, and applications to the Court of Protection, page 61, MS 2480. The prognosis for recovery is set out in Annex 1B, which I've referred to, which is in the new bundle, tab 6. And page 4 of the summary makes the point that for patients in VS, the large majority of those who recover consciousness after non-traumatic brain injury have done so by 3 months. Now, there's just one further source of guidance, and I'll open that up, if I may, at tab 61, which is bundle 6, Junior. If I can give a reference to it, it won't. If you look at tab 60, there are some documents. This is a note from Mr. Justice Charles, and if you look at paragraph 6, MS 2395, there is at the middle bullet point, common ground that the BMA, Law Society, etc., should and would discuss and create a working group and the giving of guidance. And one of the consequences of that is the guidance at tab 61, which is the interim guidance, December 17, from both the, from all of the following three, the GMC, the Royal College of Physicians, whose PDOC guidance is, and the BMA. And I know it's been dismissed by Mr. Gordon as simply just tracing the law so far, and to that extent, reference is made to the law in it. But very importantly, from 2399 onwards, you will see a very detailed summary of how doctors should conduct themselves in PBS, MCS cases resulting from sudden onset brain injury. So there is reference halfway down the page to the patient's best interests, and to ensure proper consultation in such cases, we recommend doctors take the following steps. Before the RCP guidance has been followed, with MS 2399, consultant follow existing guidance from the MCA Code of Practice, as well as the BMA, RCP or GMC, hold formal documented best interest meetings, ensure attempts are made to identify all relevant people to be consulted, including friends, colleagues, not just family. Over the page, if no known family, no one else to represent their views, and IMCA should be consulted. 7, find out as much as possible. I can't help feeling this is a result of Aintree, paragraph 7, about the patient's values, wishes, feelings and beliefs, both generally and as they relate to the current situation. Paragraph 8, all of this information should be carefully assessed in relation to the most realistic prognostic evidence to consider whether continuing CANH should be in the patient's best interests. And 10, seek a second clinical opinion from a consultant with experience in prolonged disorders of consciousness who has not been involved in the patient's care. Keep a very detailed record of discussions and a detailed clinical record. And then there's reference to parties agreeing, parties not agreeing, parties agreeing at paragraph 13, and palliative care plan, if a decision to withdraw is made, should follow the guidance in the PDOC guidance. There are detailed requirements for a palliative care plan. So that is the guidance that exists. And I say, with the greatest respect, that Mr. Justice Baker, in his Shrevell lecture, was wrong because he places too much weight on the precise diagnosis and not enough weight, I say, on the decision as to prognosis, which is most clearly relevant to best interest. So in a person who doesn't even want to be in a care home, like M case, it might not matter whether they're in an MCS or a PVS. And that's why I say, with the greatest respect, Mr. Justice Baker, who's an obviously extremely experienced court of protection judge, his particular opinion on this matter is not one that the law should adopt.
Mr. Sanchtiva, looking, as I have been, at Mr. Justice Charles's note of July, he is talking about a working group with the BMA involved, Law Society, Ministry of Justice, MOD, and no doubt other stakeholders. Is this working group still functioning and working towards the giving of guidance?
I'm seeing nods behind me, my lord. Apparently, yes.
Can we get a bit more information from
there is
something about this
apparently
working group?
it's due in May. Apparently the report is due in May, but oh right, yes, there's reference to it apparently in the written case of the BMA, which I will open.
Oh, so this is the group that's
Supplementary.
given the interim guidance
Yes.
just after Mrs. Justice Farrell's decision. Is that right?
Well, let me check, my lord.
And who are the members of it, Mr. Sanchtiva?
The members of the, apparently it's supplementary page number 91, paragraph 29 onwards. This appears to be, that I can obtain chapter and verse, my lord, a group that the BMA has constituted because of their own desire to produce guidance. I need to make inquiries as to what's happened in relation to the group which seem to have different constituents in the note. So I wouldn't want to make a definite statement on that.
Let's have some further and better particulars,
I can certainly provide that. My final...
preferably by agreement.
Yes,
the official
we'll obtain it
solicitor as to
by
what the
agreement.
situation is.
Final 2 points. On the point that there's no voice without the OS, there's no requirement the OS is the litigation friend in any case, in every case. The OS simply inquires into wishes and feelings, the source of wishes and feelings being the same source that the clinicians have, the relatives and friends, and also seeks permission to commission a third opinion, and that may or may not be granted. But that is the extent of the addition of the official solicitor. It's been very, very valuable in a number of cases, I don't deny that at all, but that's the concept of the voice being added, and effectively the inquiries into best interest and then a further third opinion. And my final closing point is to answer the 2 questions I posed at the beginning, which I say is what this case comes down to, is first of all, that my submission is that this subcategory of withdrawal or withholding of CANH from patients in a PDOC is not a sufficiently different category to justify a separate procedural regime, that there is some particular vulnerability about these very ill patients compared to all the other very ill patients that the medical profession deals with. And secondly, there is a sufficient body of experience built up since Bland to justify abrogating the rule of practice. And unless there's anything further, my ladies and my lords, those are my submissions.
I think not. Thank you very much, Mr. Sanchtiva. You're a little bit over time,
I'm sorry about
we'll
that.
have to give Mr. Gordon a bit more time. Do you wish to add anything, Ms. Dobson? Mr. Gordon.
My ladies and my lords, before I embark on a short reply, may I make the preliminary point that the official solicitor is very mindful of the fact that delay in these cases can cause distress and obviously sympathetic to the facts of any particular case, including the detail that we've had read out. But the issue at the heart of this appeal may come down ultimately to a very simple, may I describe it as a constitutional point. And I say that because it's necessary to make a few distinctions. And with great respect to Mr. Sachdeva, he has not made any of these distinctions. The first distinction is between a practice direction and a code which has statutory consequences if it is not followed, a code which is embodied in legislation. The second set of distinctions is between a state procedure which is binding, a state procedure which is non-binding, and a non-state series of guidelines. And with the greatest possible respect to the argument against us, this is a case where there is, I should say, by the way, that a state procedure which is non-binding can nonetheless be embodied in legislation. With great respect to the arguments against us, what this case ultimately is about is the fact that there is a state procedure for this type of case. And that state procedure is contained in the Mental Capacity Act Code of Practice. Now, it's important historically just to see where the code might fit in. I should say, of course, that this code is not challenged, its legality is not challenged. Indeed, paragraph 29 of Aintree, as Mr. Sachdeva recently read out, your ladyship and the court accepted its accuracy. But there is no
Accepted the accuracy of the paragraphs that were cited in Aintree.
But there's no question here that the paragraphs we have cited are not accurate, an accurate statement of the law.
Well, they were an accurate reflection of the state of House of Lords authority and the practice direction at the time. That's what they were.
But the code exists. The code exists, and the code is binding to the extent set out in section 42, which I'm going to come to. But that's the point. The point here is that the code may have come into existence as a result of historic decisions, and indeed, we have a note, happily virtually the same as Mr. Sachdeva's, which shows the historical genesis of the code requirements in relation to PVS, PDOC conditions. But that is nothing to the point as a matter of constitutional application of principle, because what Mr. Sachdeva's argument ultimately comes down to is that he asks you to substitute, to legislate, to prescribe professional or stakeholder guidelines, non-binding of course, for a binding code, binding to the extent, as I say, set out in section 42. And at the very beginning of his address, he skirted this issue by saying, it's not our case that the practice direction contains more than a rule of practice. The practice direction has got nothing to do with the correct analysis of this case. The correct analysis of this case ultimately comes down to the content of the code. Nobody has asked your ladyship or the court to quash the code, quash the provisions on the basis they're unlawful. And indeed, how could they be unlawful if they give enhanced protection rather than the protection, more limited protection, which my learned friend Mr. Sachdeva says is appropriate? May I hand in on?
Can I just, I mean, your case says on the code, paragraph 96, MS 91, while not having the same force as a statutory provision, the code is still a guide which Parliament had anticipated would be followed, departure from which should require careful explanation. See SBC versus
There's
PPA.
nothing inconsistent with what I've just said.
Well, it sounded to me somewhat inconsistent for a moment. I mean, indeed, the whole way you were putting it didn't sound very consistent with the way you were putting it in opening. This emphasis on the code is rather new, isn't it?
My Lord, we took this court to the code, to the relevant provisions of the code.
Yes, of course, but you didn't put it in terms, as you've just been putting. Mr. Sachdeva is asking you to legislate for a binding code.
I didn't realise, this is something I have to clarify, particularly as regards some of your Lordship's questions. It's never been part of our case that the guidelines are in some way legally defective. It's never been part of the way we use the guidelines, that's to say particularly the Royal College of Physicians guidelines, is to bolster our case in terms of the detail and to unravel points made by Mr. Sachdeva. What we say simply is, it's wholly unnecessary to go to the guidelines, the detail of the guidelines, to resolve the priority of the code. And what I did say in opening was that the provisions of the code unravel completely Mr. Sachdeva's submissions as to the effect of the common law, or as he would put it, the non-effect of the common law. So, can I just hand in our note, if it hasn't reached you, on the questions that Lady Hale asked yesterday, just before the lunch break. Because I think so much of this matches what Mr. Sachdeva has said. Thank you. May I take as read the first 8 paragraphs of this note, which actually I think, and we did our research separately, match the relevant Hansard statements on the amendment and why the amendment was not. That's when I say the amendment, the recommendation of the Law Commission was not followed. But if you look at 9, page 5 of this note, consequently, it appears that the reason that the bill did not contain the proposal contained within paragraph 6.21 of the Law Commission's report, number 231, and we have that report, as my Lord Lord Wilson asked for yesterday, was that the government considered that the amendment of the proposed statute in the event that medical and legal practice developed to a stage at which an application report was no longer necessary, if CANH was to be withdrawn, could be avoided through amendments to the proposed code, which would accompany the Act. That may have been regarded as a simpler and more efficacious, I think the word there missing word should be solution, than the introduction of an order by the Secretary of State as suggested in paragraph 6.21 of the Law Commission report 231. But the whole point was this: the legislative intention of Parliament was to create either additional treatments which would be protected by the code, or no doubt by amendment, to remove certain classes of case.
You haven't actually photocopied the whole report, have you?
Yes, we have, because my Lord Wilson asked for it yesterday, I think.
Did you want the whole report?
I thought you had.
I said the relevant bits.
Well,
the relevant chapter, I think I might have said. Yeah.
I'm very sorry if we've done too much, but we thought it best, in a case of this kind, to give the court as much material as might be necessary.
Loads of copies of it.
So I apologise if we've given you too much, but it's an excess of zeal rather than
yes,
anything else.
Yes, excessive zeal is not
Some-
a criticism.
Well, sometimes it's not laudable, I accept that. But the point here is that that was the historic basis for the inclusion of those paragraphs in the code. But there is a difference between an explanation of the historical genesis of particular provisions and what my learned friend Mr. Sachdeva's case relies on, which is effectively to say that he's just said it over the last half hour. You can rely on this body of professional guidance, not state guidance, professional guidance, and you can substitute, indeed you should substitute it for the code. And we say that is simply legally vacuous. It simply cannot work as a solution to what are, we accept, very difficult problems. There is going to have to be some form of solution, but the solution does not lie in citing mounds of non-state guidance. None of the cases on Article 2 are, well, the fact that you say a state has a margin of appreciation says it all. It's the state that has the margin of appreciation, not the professional bodies circulating reams of paper.
But so does the argument amount to this now, that the code makes it obligatory to apply in these cases to court, and therefore that's the way it is until the code is changed?
I'll tell you exactly what we say. We say this, that it may be necessary at some stage to amend the code.
Well, could we just deal with the first
Yes.
question?
Yes.
Is your case now that the code makes it mandatory to apply in these cases?
It is my case, but I should qualify it by saying that it has this effect, not that every single case will necessarily reach the court, but that if a case does not reach the court, there may be consequences later in terms of civil or criminal liability. That's the way it...
Does it not reach the court because it's settled after the proceedings are issued, or because proceedings are never issued?
No, it may be that proceedings are never issued.
Right.
The point really is that the code sets out what should happen. That's the only, to use the concepts in Lambert, it's the only prescribed procedure. There is no other prescribed procedure. The guidelines are not a prescribed procedure within the meaning of any conventional common law requirement. So what you've got is a legal set of requirements, but they do not necessarily compel, I think, the fact that the case will necessarily reach the court.
So neither the court has to make them in 618, nor application should be made to the court
Yes.
in 818, on the way you've just put it, actually mandate an application to the court.
Well, but it's because, can I take your ladyship to...
We'd have to see section 42 to
42. I wanted to go...
explicate your argument.
I wanted to go to section 42.
Yes.
It's 42.4.
Yeah, exactly. So if you go to Authorities Bundle 1, Tab 1, what section 42 says is, first of all, that the Lord Chancellor, 42.1, the Lord Chancellor must prepare and issue one or more codes of practice, and this is for guidance. The Lord Chancellor may, from time to time, revise a code, that's 2, and then subsection 4, it is the duty of a person to have regard to any relevant code if he is acting in relation to a person who lacks capacity and is doing so in one or more of the following ways. And I suppose, well, the family wouldn't come into this at all, I think, but the clinicians would under E, professional capacity. And then you get 5, subsection 5, if it appears to a court or tribunal conducting any criminal or civil proceedings that A, a provision of the code, or B, a failure to comply with a code, is relevant to a question arising in the proceedings, the provision or failure must be taken into account in deciding the question. So it links the code with civil and criminal liability, but it doesn't say, if you don't bring a case to court, you will be criminally or civilly liable. But my point is not. My point is a very simple one, and it's entirely consistent with our case. It is that if you take away the code, you haven't got anything. You have not got any protection in the form of state guidelines, whether binding or non-binding. That's the simple point. And I do want to...
You could have, because are we not an emanation of the state?
Emanation of the state, but nobody's...
If we were to say, I'm not saying that this is what we were going to say,
No.
but were we to say, you don't have to go to court in every case or in a particular classification of case, but you must do at a minimum X, Y, and Z.
Well,
Wouldn't that be the law?
I'm not sure. May I take you... I need to go back to 42 to see exactly how the code is... if you go to 43, before preparing or revising a code, the Lord Chancellor must consult various people, and then it's laid before Parliament. So this is a code which has to be laid before Parliament before it can claim force. Now, absolutely, a court would have jurisdiction to declare that a provision or provisions of the code are unlawful. Fully accept that. But why I said at the beginning of the reply that there is at least potentially a constitutional issue here is whether the court itself, by judicial legislation, can negate part of the code when it is not being claimed in proceedings before the court that the code is in any shape, size, or form unlawful. That's the point. And that is a constitutional point of significance because Mr. Sachdeva does not suggest that the code is unlawful. He has not brought a claim based on irrationality or illegality. So that is why we say, my Lady Black was kind enough to say I had a route map earlier on, or suggested route map. This is what I gave the court perhaps was a bus route, and what I'm attempting to give the court now is a Ferrari route, because very clearly Mr. Sachdeva has based his case on an amalgam of guidance which is non-state guidance, and it cannot stand against the code. Now, may I therefore, in the light of that submission, make it absolutely clear what perhaps didn't come across as clear in my address to the court earlier. We do not resort to the Royal College of Physician guidelines to attack or challenge their adequacy in terms of content. Rather, we rely on them for support for various aspects of our challenge. For example, to the continuing difficulties of diagnosis, to the very difficult nature of a best interest assessment in this very difficult area. But we rely on them on that basis and not on any other basis. As to their legal status, I've already made my submission. We don't query their legal status in terms of deficiency of content, but what we do say is that they simply cannot take priority over the statutory code. And we say that it cannot be a principled or adequate response for my learned friend, Mr. Sachdeva, either to resort to the proliferation of guidelines, or actually, indeed, to confuse and conflate the effect of a practice direction with a statutory code. And so we do not therefore say that this is a case ultimately which falls to be resolved by accepting the opinions of Professor Wade or the counter opinions of Professor Badwan in an individual case. What I do say is that ultimately the European Convention and the common law do require a procedure to be in the state's contemplation and expression. And in the case of this particular class of case, there is. And it may be that the court may make comments about whether the code should in due course be amended. But that isn't the essence of this appeal. Because what has happened in this appeal is that the respondents have come to court and claimed that they can simply do away with the code, and the implicit logic of their argument is, and has to be, that the practice which is built up by means of professional guidelines has become a procedure which trumps the code. And they simply cannot make that submission coherently. May I turn to a few other points of less fundamental importance? The LPA point, which Mr. Sachdeva started with. There's nothing in the LPA point. I think he was saying that because a person can appoint an LPA, that gives the lie to our reliance on advanced decisions as a different kind of category of decision from the sort of case we're concerned with. But we say that in substance, when you appoint an LPA, you are making an advance directive by any other name, albeit by a more circular route, because what you're doing is preserving your autonomy and right to self-determination by A, selecting the donee, presumably someone in whom the patient has confidence. Secondly, there must be a specific statement of whether the donee can make decisions about life-supporting treatment. And thirdly, the patient can state preferences and instructions about how he or she would like the donee to make instructions and what her preferences are. Can I turn to another topic, which is funding? Funding and its relevance to the appeal. At the start of his address to the court, my learned friend was asked about funding. He accepted that legal aid funding is, as he put it, a problem for families. But he didn't link that in any way to the principles at stake on this appeal. It is clear that family members face potentially enormous difficulties in securing legal aid funding in relation to proceedings for the withdrawal of CANH, as non-means tested legal aid funding is simply not available. The real difficulty this causes has been recently recognized in the Briggs case, which is Authority Bundle 2, tab 12, and may I give the court the page references, MS page 833 and MS page 854, where respectively Lady Justice King and Sir Brian Leveson made comments about the practical need for reform in this area because of the huge difficulties in getting to court. So we say, based on that acknowledged fact, it cannot be assumed that there will be effective scrutiny of treating clinicians' decision-making through relatives or friends of P. There is a real likelihood that in many cases, without the scrutiny of the court, clinicians will have, as Lord Lowry predicted in F, I think it was, become judges in their own causes. And I would ask the court very briefly to look in Supplementary Bundle 1, tab 11, at 2 paragraphs of Professor Sturman's report. So it's MS page 310 and 311. Oh, it's not in here. Is it in the new Sorry, I'll get the right reference for it. Oh, it's 204. I obviously have a wrong reference. But it's paragraphs anyway, 310 and 311. So 310 at supplementary MS page 217, paragraph 310 of Professor Sturman's report. An additional concern that I believe should be considered excuse me, is that where there is a dispute about diagnosis, prognosis, or best interest, particularly where family members are not in agreement with a local clinical team, then the initial action to challenge any decision may now need to be brought to the court by the family if the treating trust believes they've discharged their duty of care appropriately. There's no longer any legal duty for a trust to bring such an action with the new interpretation of the law. That's a reference, I think, to Briggs. The complexity and cost of bringing an action to court is a strong disincentive to relatives and carers to contesting in-house best interest decisions and contrary to the spirit of the Royal College of Physicians guidelines.
Do I understand this? Because I thought it was accepted on the other side that if there was a disagreement between the clinicians and the family, the trust would have to bring an action.
Yes, but this goes slightly differently. The point that I'm making here is that the colossal, well, perhaps the impossibility really of bringing a challenge will be a disincentive or a deterrent on relatives not to challenge what they're being told. That's the point. So it's not so much that mechanistically there isn't a duty to take the case to court if there's a disagreement. It's the impact of the impossibility of ever getting to court through a relative's challenge that can affect and that's made out too at, I think, paragraph 311 of Professor Sturman. So the importance of this is that it erodes completely in our submission the sense, utility, or rationality of using agreement of the family as the legal touchstone of whether there is doubt about a clinical diagnosis or a best interest assessment. In circumstances where in the real world the clinical assessment cannot be challenged effectively, it means, and it has this effect, my lord, that the relative's agreement to withdrawal of CANH may more easily be obtained. That's the point. It makes the hard line that Mr. Sachdeva seeks to draw between cases of disagreement and cases of agreement incredibly watery and fluid. Now, I want to make it absolutely clear that it is our strong submission I move now to no best interest assessment in this case, that my learned friend in his oral submissions said the learned judge reached the right decision on the facts. Well, can I make it clear? We do not challenge, and we do not seek to challenge in this case, any best interests conclusion in relation to Mr. H.Y. But the point is there was no best interest conclusion, save by reference to generic facts. Now, what my Lord Mance put to Mr. Sachdeva when he was making his submissions is, well, the judge, although she didn't put it, and I think this is the way Mr. Sachdeva put it in response, although the judge didn't put it in terms of there being compliance with the guidelines, she didn't have, I mean, that was really what she meant. Well, two things. First of all, how would you ever know whether there was compliance with the guidelines, if they were relevant, except by court scrutiny? But secondly, and importantly, let me just find it. I'm sorry, I've forgotten the very point I was going to make here, but secondly, I go back to the point I started with. It's clear, isn't it, that if the judge had said that provided there's compliance with the guidelines, the actions are lawful if family and clinicians agree, it would have been an unlawful declaration because it would have missed out the code. So we do with respect say that however you look at this declaration, there was no best interest assessment and it is an unlawful declaration. It's fair to say, in fairness to Mr. Sachdeva, that he chooses his words more carefully in his case than he did before the court in our submission, because at paragraph 99, he refers to the learned judge deciding the case, quote, on the basis of the facts of the case before her, which to our mind is an acceptance that on the basis of the generic facts, agreement with clinicians and relatives, the judge was entitled to decide the case as she did. But the point we make is that coming immediately as it does before paragraph 100 of the case, it can only mean exactly what we suggest it means, namely that the generic set of facts involving 1, a clinical judgment, 2, an evaluation of best interest, and 3, the agreement of the family, is sufficient. Now, we have a lot of points on the detail of the nature of PDOC, and I don't want to spend too much time on those, save by way of example. But the first point that Mr. Sachdeva made when he started his submission was that our analysis was idiosyncratic to focus on CANH. What he asked forensically about withdrawal of ventilation in respect of a PDOC patient and withdrawal of ventilation for other patients. And with respect, we say, by reference to the guidance itself, that kind of submission, and I can only deal with it in relation to that kind of submission, betrays a misunderstanding of what a diagnosis of PVS entails. The first point to note is that the RCP guidelines demonstrate why withdrawal of ventilation makes no sense in relation to a PDOC patient who's been diagnosed as being in a PVS condition. A patient with PVS and without the possibility of MCS has no consciousness because his or her cortex is no longer functioning, but the brainstem remains intact. What this means is that the PVS patient can breathe unaided. A fortiori, the MCS patient who may, and perhaps this isn't fully, it's quite important to grasp it, an MCS patient may, depending on his or her state of consciousness, be able to walk around. They're not linked always to tubes or in any way in that sense. A diagnosed PDOC patient does not require ventilation. So this is all explained in the guidelines themselves. Can I give you a reference? Authorities Bundle 6, tab 62, page 1, MS page 2420, and I'll read it. These guidelines concern the diagnosis, management, and lifelong, including EOL, end of life, care of adults who have prolonged PDOC persisting for more than 4 weeks following sudden onset profound acquired brain injury. Then the guidelines we say presuppose that PDOC patients are clinically stable at the time of assessment. We see that from the expressed need for a formal structured observational assessment of behavioral responses. See the same document, page 2437, and on the same page, and I'll read it. Formal assessment is essential in the following circumstances: to establish initial diagnosis and as baseline to guide future management. As part of the assessment, we're making decisions about the potential withdrawal of active medical treatment. On the same page, assessment should be undertaken by the clinical team. Health, the patient is clinically well and free from intercurrent infection. And a whole range of other material which absolutely demonstrate, when you go through the guidelines, that a PDOC patient has got to be clinically stable. They're not going to be on a ventilator. So this is not an idiosyncratic set of submissions. When you go through the guidance line by line, and that's why we respond to it, not for any other reason, you find Mr. Sachdeva's case falling apart just in relation to the detail. Just to the
Mr.
relation.
Gordon, I should warn you, you've got a minute left.
Yes.
That's of your extra.
I knew I had a minute. Luckily, I think the clock's been
Forget the
rejigged.
clock. I'm relying entirely.
And so what I want to say, by way of a very quick conclusion, is if we're right on the fundamental point in this case, we win. And even if we're wrong, Mr. Sachdeva simply cannot rely on the guidelines he purports to say, well, don't worry, because there's so much guidance, everything's all right in this best of all possible worlds. Those are my submissions.
Thank you very much indeed.
Lady, I'm sorry to rise, but my clients are very concerned at the suggestion that all PDOC patients can breathe unaided and that they are never on ventilators. And we would like to put before the court the medical position, if that is something relevant to the court's decision, because I'm told that that isn't the case.
Well, if you would like to put in anything further about that, and obviously if it can be agreed with the officials,
We will seek to agree
that
it,
would be
my
the
lady.
best solution.
My lady, we'll do that.
Insofar as this is going to be a crucial.
Indeed.
I'm not suggesting that it necessarily is. But
I'm most grateful, lady.
My lady, just before the court rises, I have forgotten, but may I hand in a second note, just by way of detail on funding, which we thought you might be interested in, how the official solicitor is funded, and also on the IMCA, both points that I think my lady, Lady Black, raised. They're quite neutral notes. I don't think they're going to do anything other than instruct.
well, I hope they've been agreed with the other side.
We've not seen them,
I'll have a look.
lady. But
Sorry. Well, perhaps we should agree them and then hand them in.
That would be the best solution in both cases.
Absolutely.
Thank
Thank you very much.
Yes. Well, we're grateful to everybody for their arguments, both oral and in writing, and to those who've not had the opportunity of getting to their feet. We're nevertheless grateful to them for their very helpful interventions, and we will now go away and consider what the answer which we give is. I'm not claiming ours is necessarily the right answer, but it will be the one that we give, I hope. And we will let you know that in the usual way.